Good afternoon, and thank you for joining us today. As our attendees are joining the webinar, I'd like to provide an introduction for this afternoon's book and our speakers. This is our second Office for the Advancement of Research book talk for the fall 2020 semester, featuring John Jay's own Veronica Michel on her 2018 book, Prosecutorial Accountability and Victims' Rights in Latin America. This was deferred from our spring, our Disrupted Spring series, and we thank Veronica for being willing and able to roll with the punches, as it were, while we figure things out and moved our entire operation online. So thank you for that, Veronica. And to introduce our speakers today, Dr. Veronica Michel is Associate Professor in John Jay's Department of Political Science. Her areas of research focus include human rights, victims' rights, criminal procedure reforms, norm diffusion, cause lawyering, and legal mobilization, comparative and international criminal justice with a regional focus on Latin America. She is a past winner of John Jay's Donald E.J. McNamara Award for contributions to the field of criminology through her research and scholarship. Dr. Michel will be speaking today on her 2018 book, Prosecutorial Accountability and Victims' Rights in Latin America, which draws upon her expertise as a human rights scholar to examine issues of legal mobilization, cause lawyering, the interactions between domestic and international law, state capacity, and rule of law in Chile, Guatemala, and Mexico. The book won the 2020 Outstanding Book Award from the International Section of the Academy of Criminal Justice Sciences. And joining us today is, as a commenter and moderator, is Dr. Janice Gallagher, who is Assistant Professor in the Department of Political Science at Rutgers University, Newark. Prior to joining Rutgers, she was a postdoctoral fellow at the Watson Institute for International and Public Affairs at Brown University. She's about to submit her first book manuscript entitled Bootstrap Justice: The Search for Mexico's Disappeared. She conducted more than 2 years of field work in Mexico and Colombia, and previously worked as a human rights accompanier in Colombia. Let's welcome Janice and Veronica. Thanks for joining us today.
Thank you. I hope you can hear me. I think you can. Welcome, everyone. I'm really thankful for this opportunity to be talking to you. As Dan mentioned before, this was supposed to happen in the spring, and then the pandemic happened. So the silver lining of all this is that we are, I hope, able to reach out to a broader audience, because I can see that there are some students, but also friends and colleagues from other places joining in, and from different spots in the world. So I'm very happy about that. So welcome, and let me first share my screen so that I can put my slides on. Okay, let me find it. Sorry about that. And okay, so one of the, let me just, sorry about that. I think you can see the whole thing. Can you see the, oh, I think you can see as, I see, you cannot see the slides per se. I wasn't thinking about that. Okay, let me see if I can make this bigger. Sorry about that. Okay. The thing is, I have some written notes and I need to read them at the same time. And I think if I do it as presentation format, I lose my notes. So sorry about that. I wanted to do the full screen, but I will have to do it like this. Okay, so about the book. As most of you know, Latin America has long been perceived as a region that has continually failed to consolidate and uphold human rights and the rule of law. The failure of the criminal justice systems in some of these countries cannot be exaggerated, as these systems continue to violate the rights of both defendants and victims. This has been tragically depicted in the mural created by the hyper-realist Mexican artist Rafael Cauduro, a section of which is featured as the cover of my book. This mural, located in the Supreme Court of Mexico, highlights a legal system that is overburdened by case files that appear to be neglected, abandoned, by a system that ignores victims, abuses defendants, and where impunity prevails. So in this book, you will find stories about unimaginable grief and loss, but also about relentless hope. In this book, I try to show how, against all odds, relatives of victims get to see their day in court. Now, before I get started, let me briefly explain how this presentation is organized. Although this book is ultimately about hope and the rule of law and in finding justice, this is not at all how this book started. This is why I want to start with a brief introduction about that. Then I want to talk a little bit about the research questions that I have and the methods. And I'll highlight some of the key findings and arguments, and I will highlight some examples from Mexico. Okay, so how it started. Okay, this is becoming a little bit distracting, so I'm just gonna do the whole screen because I'm getting confused. Okay, so as I was saying, the book, even though it's about hope, it didn't start as such. While I was a graduate student a long time ago, 12 years ago, I, like many folks at the time, I was very curious about the many reforms that countries in the region were undertaking as after they transitioned to democracy. Some of the main reforms that they were implementing, and probably one of the most ambitious ones, were the criminal procedure code reforms, which basically aimed to change the process of criminal prosecution from what is called an inquisitorial model towards an adversarial model. And all of the countries, as you can see in this chart, started to implement these changes in their criminal procedure code or CPCs. And one of the things that I noticed right away was that they also expanded victims' rights. So not only defendants' rights were being implemented, but victims' rights were exponentially being expanded through these reforms. And this is really what caught my attention. What were these victims' rights doing in criminal procedure code? And as you can see in this table, which is not included in the book, but it's part of basically a continuation of this research, and what I'm doing nowadays is that, as you can see over time, the older criminal procedure codes in the region rarely mention the word victim. And as countries introduce new criminal procedure codes, the mentioning or the reference to things related to victims basically exploded. So rights for victims were increased in these reforms. And one of the key rights that was introduced through these reforms was the right to private prosecution. The right to private prosecution is a procedural right, which means that it gives victims or their relatives, in the case of homicide victims, the right to participate in pre-trial and trial stages. It gives them, and this is probably one of the main tools or one of the most powerful tools that private prosecution gives to victims, is that they have the right to appeal key prosecutorial as well as judicial decisions, like the decision to not prosecute or the decision to dismiss a case. And this is very important, as I will show later. And it also gives the right to victims to participate in both the criminal investigation of the case as well as the whole prosecution. There's a catch, obviously. It's a costly right. Victims need a lawyer to do this. So it's not like anyone can just join in. You have to have legal skills or hire a lawyer or find an NGO that does it pro bono. Now, what this looks like is something like this. So this is a screenshot of an oral trial in Chihuahua, Mexico. This is actually the first trial with a private prosecution in Mexico. And as you can see here, you have the judge in this corner, the defense in this corner. Here, where it's gray, you would have a witness in the stand, but at the moment of the screenshot, there was no witness in the stand. And in the lower, I guess it's right corner, it's the prosecution corner. And there are 4 people here. 2 are part of the Ministerio Público, or the public prosecutor's office. And on the other side, sorry about that, you have the private prosecution, the lawyers for the victim. So this means, as I said, it's a participation right. They're actively involved in trial and pre-trial stages, and they participate actively. Next to the private prosecutor, it's important to highlight that they do not replace the public prosecutor. The state always remains there. Okay, so as I was doing this research, and I found that victims' rights had been exponentially increased in this region, I also noticed that designers, legal scholars involved in the design of these new criminal procedure codes really thought of private prosecution as a way to have a check on a public prosecutor's use of her prosecutorial discretion. Let's remember that public prosecutors around the world are granted very important powers. They have the power to investigate and prosecute folks. So it's not a small power that they have. And legal scholars involved in the design of these new criminal procedure codes really thought of private prosecution as a check. And that really got me intrigued, because at the time there was no empirical research on this right. So we didn't know, first of all, if it was being used, or if it actually worked as intended, as a prosecutorial accountability thing. So I started my research with basically 2 questions: if private prosecution was being used or not, and then if it actually is being used, if it actually works as intended, as an accountability tool, and if so, when and how it works as an accountability tool. So with these research questions in mind, I selected 3 countries to conduct my research: Chile, Mexico, and Guatemala. The selection strategy is basically called diverse case selection. I don't want to bore you with methodological details, but it basically is useful when you have very little information about a particular phenomenon, and this actually lets you select cases that vary a lot on important factors. In this case, I chose countries that varied a lot in factors that are known to impact access to justice and how a judicial system responds to crime. So I selected countries that varied a lot in development, how much foreign aid they get for judicial reform, how much money the public prosecutor's office gets, or the PPO, if the public prosecutor or the PPO is autonomous, or if it depends on the executive branch, how violent the context is, how many homicides per 100,000 inhabitants there are. Guatemala at the time, this is, as I said, it was a while ago. In 2008, Guatemala was the most violent country. Mexico later, unfortunately, caught up. And also clearance rates. This is probably a very important factor that I took into account, because I wanted to see how countries that were known to have different capacity to respond to crimes actually dealt, or if they had private prosecution cases or not. So Chile at the time had, and it still has, a clearance rate comparable to that of the United States, which is basically 40% of violent crimes are cleared by an arrest warrant or an indictment. In Mexico, only about 10% of violent crime cases reach this stage, compared to Guatemala, which is only 2%. And for homicide cases, the rates are actually worse for both Mexico and Guatemala. So I had very different countries. And I went to these 3 different countries and I gathered very different type of information to try to see if private prosecution was being used and if it mattered. I conducted different fieldwork trips during the years, between the years of 2009 to 2011. I interviewed mostly lawyers, activists, public prosecutors, and legal scholars. And I observed trials and hearings. And I also gathered actually data on murder cases. I created 2 different data sets. One that basically gathered information on murder cases, which I called ordinary murder cases, where the defendant was basically an ordinary citizen. And then I gathered information for what I call state-sponsored murder cases, which are basically human rights cases where the defendant is a state agent. And I tried to assess if in these 2 different type of murder cases, ordinary or state-sponsored murder cases, you had the presence of private prosecutors. And with the data that I gathered and the findings, basically this is how I constructed my book. So the book basically divides the findings in 5 different chapters. In the first chapter, I basically explain how private prosecution can be thought of as an accountability tool. In the following chapter, I explain a little bit of the history of private prosecution in the region. And then in the 3 last chapters you have basically the beef of the book, where I provide the findings for Guatemala, Chile, and Mexico that offer different interesting findings on how private prosecution is used in these very different contexts. In this talk, I will mostly talk about private prosecution as an accountability tool. I will explain basically the argument of the book, and I will highlight how this works using some examples from the chapter on Mexico. Now, what I found, and I can give more details later in the Q&A, but basically what I found was that private prosecution was indeed and is indeed being used, both in ordinary murder cases as well as in state-sponsored cases. What I also found was that there was a difference or different patterns in how much they are being used. So in Mexico, I found virtually very little use for private prosecution in state-sponsored cases and low for ordinary murder cases. In Guatemala, I found high use of private prosecution for state-sponsored murder cases and very low for ordinary murder cases. And in Chile, I found high use of private prosecution in both ordinary murder cases as well as state-sponsored murder cases. The reason for this is that there are different conditions that allow victims to use the right to private prosecution. So across countries and types of crime, private prosecution will be used when there's a legal opportunity structure, basically when private prosecution is part of the legal stock available for citizens. Also important is the political opportunity. In other words, if victims have an appropriate context to push for this or claim this right. On the one hand, there has to be a context in which they are facing impunity, they're facing obstacles to access the justice system, so they have an incentive to do that. But they also have to feel that they can access the court because it is safe to do so. And there has to be certain expectation. There also has to be obviously an awareness that they have the right. So there has to be some knowledge across citizens, among citizens, that they have this right. Also, you have to have a support structure in place, and mostly this is given by NGOs. As I mentioned before, Private prosecution is an expensive right because it requires a lawyer, and most of these victims do not have the resources for a private lawyer. And one of the main ways in which victims are using this right is through NGOs. So that explains a lot of the variations in how much countries are using this right, because these different conditions have to be in place. Now, does it work as an accountability tool? And what I found is that yes, but it has to be in context of prosecutorial failure or impunity of some sort. I also found, and this is probably one of the interesting findings of the book, is that how a prosecutor fails to investigate and prosecute a crime can be both a result of commission, what I call a sin of commission, or a sin of omission. Think, for instance, human rights cases, which are usually failures to prosecute because the state has very little incentives to prosecute state agents for human rights violations. So what I found is that in countries that have had the right to private prosecution for a longer time, like Chile and Guatemala, private prosecution actually helped cases reach a trial. So compared to Mexico, where less than 25% of the human rights cases in the sample made it to trial, in Chile and Guatemala, more than 50% of the cases actually reached trial. There's also an impact in how much information we get about the cases. Mexico, that had no private prosecution at the time that the sample covered, for instance, there was a lot of missing information on what happened to the cases. So basically they remained ongoing. Maybe the claim was pressed, the prosecution started, but the case remained ongoing and nothing happened. Whereas that chance decreases quite a bit in Chile and Guatemala. I must say as well, and I think I mentioned it here, that these findings were also replicated in an article that I published a few years ago with my co-author, Jeff Dancy, where we show that countries that have private prosecution in Europe and Latin America have actually an impact in the likelihood of having more trials in a particular country. So beyond these three cases, I have found that the findings actually replicate elsewhere. Now, in cases of ordinary violence, I found the same thing. So you have to have prosecutorial failure because the state is not prosecuting cases. In the case of Chile, for ordinary cases, the public prosecutor office tends to be quite efficient. So cases tend to be investigated, and this meant that private prosecution had less of an impact in Chile in ordinary cases when compared to Chihuahua and Guatemala. In cases where the public prosecutor's office, as I mentioned before, Chihuahua and Guatemala have very high rates of impunity, very few cases, more than 90% of the cases remain without an investigation. And this is huge. And in this context where the public prosecutor is basically failing to investigate cases, private prosecution has a stronger impact. So if you see this table, what I found was that in the data set that I gathered from cases in Chihuahua and Guatemala, Chihuahua, a city in Mexico, I basically found that not having a private prosecution, a murder case without a private prosecution, has a 20% chance of remaining ongoing, has a 24% chance of being dismissed, and has a more or less a 20% chance of going to oral trial. Compared to cases where you have a private prosecutor, the chances of the case remaining ongoing basically decrease to less than 10%, about 7% chance of the case remaining ongoing. It also reduces the chance of dismissal to 12%, and it increases the chances of a case to go to trial. So basically what I found is that private prosecution works as an accountability tool because it improves the criminal investigation and it helps to push cases to the next stage. So a criminal investigation, prosecutors are, private prosecutors, I'm sorry, are able to improve the investigation so that the case is strong enough to move to the next stage, maybe to an indictment, and then to a trial. And this has been probably most studied in human rights cases, like for instance, the trials against Pinochet in Chile or the trials against Rios Montt in Guatemala. But I also found the same patterns of how it impacts ordinary cases. And through their litigation work, I further argue in the book that private prosecutors are basically building the rule of law from below and also from abroad when they, and they do it quite often, when they reach to international courts to try to push the public prosecutor or the justice system basically to respond to a claim. And the way they are able to build the rule of law from below is through the following three mechanisms. Their litigation efforts tend to have demonstration effects beyond the case that they're working. And I'll explain a little bit with cases from Mexico how that works. They also inspire and or push other actors to engage in pressing for justice. And one of the few things that I noticed that is very important, especially when NGOs are involved as private prosecutors, is that they help build the rule of law from below because they are either able to create innovative legal arguments that open the space for cases to move forward when they are facing amnesties, for instance, or when a court is basically not responding and they want to appeal a decision and they come up with a very creative legal argument that opens the door for cases to move forward, or when they bring into their legal argumentation international norms. And I will explain next how this has played out in the case of Mexico. So the case of Mexico I found very interesting because it's a case where private prosecution is less known. It's a virtually pretty new right. And in part, as I was mentioning before, it explains why I found very few cases of private prosecution being used. So the chapter in Mexico is really a chapter about how grassroots organizations, how victims, relatives, and victims' lawyers basically discover the power of the right to private prosecution. So I kind of mentioned before that for decades in Mexico, human rights cases virtually didn't have any litigation, at least not with the participation of victims' relatives. This was quite evident in some of the most well-known human rights violations in the history of the country. For instance, in the 1960s, the Tlatelolco massacre, where hundreds of students were killed, tortured, and there was virtually no accountability for those things, for those human rights violations. In the 90s as well, the Acteal massacre, where over 40 indigenous people were massacred, mostly women and children. There was some accountability there, but then the convictions resulted to be actually overturned because they were found to violate due process rights. So, and in these processes, there were no lawyers for victims other than trying to, mobilize on the streets any accountability. They didn't really have a recourse other than the amparo, which, but it doesn't really open the door to appeal a decision or to introduce evidence. The amparo gives you some recourse, but not as strong as the right to private prosecution. This was also quite evident in the femicide cases. So Mexico, unfortunately, became widely known because of femicide cases. The femicide cases became known in the 1990s because a bunch of bodies were found in the cotton field. Well, actually before that, in the 1990s, they were first reported by local activists, and they identified a pattern of missing women. And then in 2001, the cotton field murders caught international attention. And since then, more than 45,000 women have been reported as being killed. Virtually very few of these cases get any investigation, and even less cases ever reach trial. And from that 4%, even less get a conviction. So very few cases involving femicide get any day in court. And it started to change in the late 2000s with the introduction of private prosecution. Now, a little bit of the history of private prosecution in Mexico has to highlight that the first time private prosecution was introduced in the country was actually in a state criminal procedure code. Mexico is a federation like the United States, and the state of Chihuahua reformed its criminal procedure code in 2007 and introduced private prosecution for the first time in the legal history of the country. Private prosecution was unknown in the country, contrary to Guatemala and Chile, where private prosecution had existed for decades. Later on, there was a constitutional reform in the country that expanded victims' rights and basically granted important rights for victims to participate in their cases, which was further buttressed by the 2013 Victims' Rights Law, and then by a new criminal procedure code at the federal level that basically created a unitary criminal procedure code for the whole country. Now, how private prosecution has been used across the country really reflects this issue that I mentioned before, that grassroots organizations as well as victims have to be aware of this right. And the first instance of this awareness of what the private prosecution right meant and the power it could have really happened in the state of Chihuahua, where victims organizations were quite involved in the reform process of the criminal procedure code in Chihuahua. And they were in charge of the first private prosecution of a case of attempted femicide, which is the case of Lolita. So the picture that you saw before, the screenshot of that trial, is basically the first private prosecution case in the history of Mexico. And in this case of attempted femicide, an organization called SEDEM basically really helped highlight how private prosecution could actually change the fate of a case. In the case of Lolita, the way that private prosecution worked was that the public prosecutor had agreed with the defense for the case to go. They basically agreed on a plea bargain, which, as you know, leads to an abbreviated procedure, which involves less punishment, et cetera, et cetera. But Lolita, who didn't die, obviously, of this attempted homicide, wanted her day in court. She wanted a trial. And with her lawyers from SEDEM, successfully argued, they appealed the decision for a plea bargain. And they, which in Mexico, in the state of Chihuahua, at least, it was called an abbreviated procedure. And they basically were able to push the case to trial. And she got her day in court. The public prosecutor had no remedy but to accept the judicial decision to concede the petition of the private prosecution. And the private prosecution, the lawyers for Lolita, helped buttress the criminal investigation. And in their legal argument, one of the interesting things that I found was that they were including argumentation that included international norms regarding women's rights, gender, violence, and all this language that the public prosecutor was not including. So they were really building up the case in terms of the legal argumentation as well as the criminal investigation. And that was the first instance of the use of private prosecution. SEDEM since then has been involved in many other cases, and more recently, as Janice can tell you better, they've been involved also in cases of disappearances in Mexico. But they basically became the beginning of what was the beginning of a support structure, NGOs litigating for cases. Through their work, they are basically improving prosecutorial accountability because they are appealing decisions to not prosecute when the prosecutor didn't want to prosecute. They appeal the decision. When the public prosecutor doesn't want to take a particular piece of evidence, they can appeal that, and they have buttressed many different cases by being able to bring certain witnesses or certain evidence into account. As I mentioned before, they have introduced in their legal argumentation important pieces of domestic as well as international treaties. And in their work, they have pushed and inspired other actors. And this is where the case of Mariana Lima that took place a few years later highlights the importance of how these grassroots efforts can help build the rule of law from below through these demonstration effects over time. As NGOs see how each other work, how they use the right to private prosecution, they can basically push for other cases to move forward. The case of Mariana Lima highlights such demonstration effect. Mariana Lima was a woman that was murdered by her partner, who happened to be also a police officer, member of the Ministerio Público in el Estado de Mexico, in the state of Mexico. And initially the case was dismissed as a suicide because the husband or the partner basically claimed that Mariana had committed suicide. And the investigation, which was poorly done, neglected a bunch of evidence regarding domestic violence, and they dismissed the case because there was no crime per se. It was ruled as a suicide. The family of Mariana suspected the partner, and they sought the assistance of the OCNF, which is basically an organization called Observatorio Ciudadano Nacional contra el Femicidio, and which is basically an observatory for femicide cases. And they tried to assist Mariana's relatives to push the case to trial. The first thing they had to do was basically appeal the decision to not prosecute. And they had, this is the first case that, the first femicide case that reached the Supreme Court in Mexico. And it was also the first case that a private prosecutor brought to the Supreme case. So this is very important. They were successful in convincing the Supreme Court that they had to reopen the investigation, that there was enough evidence that had not been taken into account by the public prosecutor. So this is about prosecutorial accountability. And they ordered to reopen the case. The case remains pending, unfortunately. Last I checked, there was an attempted murder on some of the witnesses regarding to the case, but it was successful at least in keeping the case open. And this is one of the things that I have found across all my cases, that they keep the window of opportunity open. They may not grant a conviction or more punishment, but they push cases forward and they open the possibility for victims to have their day in court. So I'm gonna wrap up now to some brief conclusions, but some of the key points that I like to highlight about this book is that the rule of law through these everyday struggles is able to be built from below And also when these private prosecutors use international courts, they can also push for the strengthening of the rule of law from abroad. There's also something to be acknowledged about how a prosecutor's office can fail in terms, it's not only about failures by intent, it can also be neglect. It obviously can be a commission, like they don't want to investigate, but there are different reasons why a public prosecutor office fails to investigate and prosecute crime. And I think there's more research that should be done on the topic. And last but not least is one of the things that I loved about this book was that I was able to show how, as a legal document like a procedural law, how it matters, how criminal procedure law that was previously neglected, particularly among political scientists, how it can matter so much for how citizens are able to use the judicial system. One of the key things that I found is that judicial independence matters, but not as much if you don't have victims' rights that allow victims to press for justice. The same with having victims' rights. Having the right to private prosecution is not a guarantee that you're going to see your day in court, much less that you're going to see punishment the way that you want it seen. So it's necessary, but it's also not sufficient. So it's part of a process, and this is some of the key takeaways of my book. So thank you for listening, and I'll now let Professor Janice Gallagher to comment.
Thank you so much, Dr. Michel. This is an honor to be able to be here and talk about this incredible book, which I hope all of you have and have read and are similarly dog-earing it and marking it up to use in your work, and also just to understand this really important issue in greater depth. I just want to say I think this is such an important book. And Veronica, I know I've watched this kind of take shape over the years. It's amazing to see the final version of it. I was thinking about the conference presentations and kind of seeing you as this evolved, and just knowing how much incredibly hard work went into creating such. It always looked so polished at the end, but it was a privilege to be able to see this as it evolved. And I just want to thank you for the trailblazing work. And for me, you have been a mentor in doing this work, and I'm just really thankful to be able to talk about it a little bit today. So I just to say before I go into my comments, it's 3:45. We're going to wrap it at 4:15. I see two questions in the Q&A. Please feel free to ask questions, and we'll get to them before the end of this period as best as we can. So. I won't go too much into summarizing, which I think Professor Michel did really well. I guess I was thinking, how do I talk about this book when in kind of what do I have to add in terms of the overall summary? I'll do that pretty quickly. I think one of the biggest things is that this phenomenon of the private prosecutors is in 14 of 17 Latin American countries, right? This is a really big deal, not just in the 3 cases that Professor Michel concentrates on in this book, but in, again, 14 of 17 countries. In 11, I think that's right, of these 14 countries, the stronger version of this, which is the autonomous prosecutor is present, as opposed to the auxiliary prosecutor. So the autonomous prosecutor, just like, and you say it in very clear language, it's pretty weird for people coming from a US context to really understand, to fully kind of wrap their heads around this idea of an autonomous prosecutor, this prosecutor who can, if the state decides not to bring charges, they can bring charges, right? So this is a really big deal and really understudied. So and it's widespread. So I think for me, you show how in 3 really different contexts, in Guatemala, Chile, and Mexico, how these private prosecutors work and how they impact both cases of homicides and human rights violations. Which is extrajudicial killings in human rights language. The key finding, as you say, is that private prosecutors, in essence, work, right? They increase the likelihood that a case is investigated, that it's not closed, and they work as an accountability tool for the justice system in these crucial cases. I think in your words, which I liked, the private prosecutor, we can understand it by thinking about the legal stock available to citizens, explains how societal actors can bring claims to criminal court and fight impunity. So again, just in some ways, this feels kind of narrow, right? We're focusing on this one, right? But it's talking in a really significant way to impunity or the failure to prosecute, which I think everybody who works on Latin America and most people who live there think of as one of the most important issues that societies are facing. These are especially in Mexico and Central America. We know that the issue of homicides and the issue of impunity are really at the top of what citizens are thinking about, and kind of is impunity is a reason that people believe that they're suffering. They believe that's a reason that they believe that their family members are being killed. It's a reason that they believe they need to leave their homes. So this is, I don't want to kind of the big picture of what an important study this is and what an important contribution this is to be lost by going into the weeds. So kind of full stop, this is a really big deal. So I want to say 5 things I appreciate about the book, and then 5 questions. So I guess I kind of just said this, but the first thing I really appreciate about this is the decision to focus on this issue, this incredibly important issue. I think it can often be, so as somebody, I also study lethal violence in Latin America. It's not always a fun thing to study. It's right, we're talking about really difficult cases. We're talking about pain. We're talking about a lot of frustrations. I think a lot of people, when you say that you're studying when you're studying the justice systems in Latin America, they're like, well, it's just broken, right? Like, and there's a lot more to it. And I think it's so important to be studying this. Professor Michel, you've taken the care to spend this time on this issue, which to the people, especially to the people it directly affects, is really everything, right? It's the most important thing in their lives. Kind of a subset of this appreciation is your findings and focus on the investigation and on keeping cases open. I think so much scholarship about justice systems is focused on, is there a conviction or not a conviction? And it's just kind of like, especially if you're not a lawyer, right? It goes into this, a crime is committed, and then it goes into this hopper, this thing that we don't understand, and either comes out conviction or non-conviction, and that's how we think about it. This fine-grained analysis of the investigative process is incredibly important, right? We don't understand really what drives cases there. Anybody who looks at this knows that that's where most cases fall off the map. Most cases that are filed are never getting, and this is the quote that starts your Chihuahua chapter, which I've quoted in my own work, perfectly captures this, right? So this, like, people file a case and then they finally get access to the case after 7 years, 8 years, and the case is 2 pages long, and essentially it's only it still only contains what that person said. So I think I so appreciate your finding that the private prosecutions affect these investigations and that they keep cases open. That's incredibly important. And again, incredibly understudied. So first thing. Second thing, you make it look easy, right? So overall, you do have a point in the Guatemala chapter, which made me like laugh out loud. You said, I had no idea getting a representative sample of homicide cases from 2 courts would be so difficult. So as somebody, again, who's in this issue area, it's so hard to get to do the kind of documentation that is in this book. 520 homicide cases, 383 human rights cases, which I know you use some pre-existing data for the human rights cases, but the process of trying to extract information is kind of half of the so I'd say part of the strategy of the state of maintaining impunity is to make it really, really difficult to figure out not only what's going on in your case, but in all cases, right? So the act of extracting information about these cases, documenting it in a legible way, and presenting it is in and of itself a really important contribution. And kind of the other half of that, I think legal lingo, especially across national context, is incredibly difficult. Excuse me. And I think one way that I'd say states, and in some ways lawyers, have have preserved justice is something that only they can weigh in on, is by making all this legal lingo really hard to penetrate, really hard to answer. This book breaks down incredibly complex legal processes and kind of in different legal reforms around private prosecutors into its most like understandable constituent parts, and presents it to the reader in a way that you can really understand how it's different across national contexts, why that matters, why all what's going on with all of these different legal terminology, which is just really important and really difficult work again. So I so appreciate that. And I kind of faced some of those challenges, and I know firsthand how difficult it is, and you've done a really artful, masterful job at presenting this incredibly intentionally complex and alienating legal language in a way which is accessible. Next thing, you break the barrier between human rights and homicide, right? Most literature, as you say, if they're, and to the extent that any literature really looks at the outcomes of these really important cases, it's mainly human rights scholars. But again, human rights scholars and a lot of the NGOs you talk about who are choosing paradigmatic cases and who are doing strategic litigation are really focused on cases where the state is the clear perpetrator. I agree with you, and I think it's incredibly important that we look at the overall capacity of justice systems to deal with cases where there is lethal violence, right? And so by looking at those in the same breath, by looking at homicides which are committed by non-state actors alongside cases that are committed by members of the state apparatus in some point, I think you're doing really important, and I think you undersell how important that is. I think that's really trailblazing theoretically. I think it's really, really important that you do that. So I think you're a pioneer at looking at those together. And I think we learned something really important by uniting analytically those two concepts, which are all too often looked at apart. And really, again, it's human rights scholars looking at the human rights abuses, and really legal scholars looking at the homicide. It's still outside the box as a political scientist to be looking at cases of homicide and theorizing them by looking at theories of the state and looking at kind of social movements and looking at all the work that you're doing theoretically with homicides as part of your dependent variable is really great. I'll try to speed it up. So another, and this will be quick because I think you explained it really well. I love the work you do on arguing that private prosecutors are a really important part of building the rule of law from below. I think you say it really clearly. To me, you're translating institutional rights into how it affects real people and their ability to address the most important thing that's happened in their lives. You talk about their bravery without kind of being sentimental about it. You're just really clear on how incredibly important it is. I think, again, all too often, when political scientists talk about the justice system, they're talking at a really macro institutional level. So they're talking about some of the reforms you're talking about, but they don't draw the through lines of how it actually affects people. So I think, and how it affects people, and in turn, how people using those systems, how these NGOs, how these oftentimes kind of underfunded local initiatives are really a key part of building the rule of law, right? So I think you do an incredibly good job of navigating those different levels of analysis. Okay, final thing I really appreciate. You argue that, I was really excited and surprised to see this. I had forgot this in my first reading. You have one graphic where you show that over time, impunity decreases. So that's really counter to what we think of, especially in the US. We think that if a case isn't solved in its first year, you're not going to solve it. And what you show is, with the addition of the private prosecutor, it actually, justice takes time. It takes time when you put another actor in there, and it actually, in some cases, makes it more likely that it'll be solved over time. So that was really hopeful, I thought, and a really important finding, and I think it's fairly counterintuitive. So I think those are some of the many really important contributions of the work. Things I want to hear more about. So five questions. The first one is about the support structure. The question is, does the need for support structures perhaps decrease over time? Right, so you talk about the demonstrate. So in terms of what it takes for the private prosecutor work, you talk about the demonstration effects. I guess in other words, in order to grow the use of the private prosecutors over time, do you think the demonstration effect of these prosecutions will ever result in victims themselves organizing, or does it in the end, do you really think is kind of the way we see this going to scale, the huge growth of NGOs, or does it go, or is it there at some point where where there's essentially benefits of not economies of scale, but kind of that there's enough of these cases that that we don't need NGOs to be accompanying every single one, or we don't need lawyers, cause lawyers to be representing every single one. And I think if there are, I think that's really hopeful. So yeah, so I wanted to kind of push on the support structure argument. Second, and this is a little related, at one point you frame the private prosecution as an alternative to protest. And I wonder when and if they're complementary, right? So sometimes people this is obviously the institutional route to getting a homicide or a human rights violation resolved. Did you see that, or do you see that? How do you think about protest accompanying those prosecutions, or is it kind of working in a counter, or do you see it kind of working counter to achieving justice within the institution? Okay, next question. In Chile, more than in any other case, you talk about the importance of private prosecution in improving the perceptions of people that, quote, the system takes their interests seriously. This is obviously connected to my own more recent work, but I wonder, why do those perceptions matter, right? Why does it matter that people are seeing the institution? And maybe it might seem like an obvious question, but I think the literature doesn't think it's obvious, right? So why does the way people perceive these institutions matter? And also, when you looked at Mexico and Guatemala, did you find the same? You didn't talk about it as much, and I'd love to hear kind of it's not as widespread, but do you think as the private prosecution gets used more, we will similarly see this this positive perception growing? Okay. Two more, and then I'm done. Auxiliary, again, to go back to this distinction of auxiliary versus autonomous private prosecutors. They seem pretty different to me. You talk about them being different, but I'm wondering, like, it was interesting to me that, so the Mexican case, I guess I wanted to hear more about that, about how different they are. To me, they're almost separate phenomenon. And do you see kind of a push from those places that have auxiliary private prosecutors? Is there a civil society push to make them more autonomous, right? So is this kind of enough on people's radar that there's a push for this? Last question. You open the book with the case of Tamir Rice. I think sadly, since the book has been published, we could have opened the book with, or you could have opened the book with the case of George Floyd, with the case of Breonna Taylor. In terms of thinking about how it's relevant to the United States, do you think it's interesting to me, and maybe I'm not just pendiente enough of conversations in the US, that I don't think I've heard conversations in terms of what are the possible institutional reforms to try to get to make some progress on specifically the cases of police killings in the United States, primarily of men of color. Do you see any possibility for something like a private prosecutor, or kind of a form of the prosecutor, private prosecutor, excuse me, in the US? So I will stop there. I'm just really thankful this book exists. I'm thankful for your work. I'm going to take a couple minutes and read the questions that have come in and give you a kind of initial chance to respond. It's 4 o'clock, so maybe if you want to talk through for a couple minutes, and then I'll break in with some of the questions that have been coming in.
Thank you so much. This was very useful, actually, and humbling, because you started with really nice comments about how this has been useful to you, at least, and that is really nice to hear, that your work can actually be useful for someone else. So there's a couple of questions that I will try to address at the same time that some of your questions, I'm going to try to also address some of the questions that have been raised. So you started with change over time and of the support structure and if it's needed. And this kind of relates to a question that one person asked about Mexico and how it's, what's the situation with the AMLO government and what's the situation for victims' rights? And I guess this kind of relates to the protest versus litigation question that you also had. And one of the things I see about private prosecution, about being useful and how grassroots organizations, NGOs have virtually exploited this right to push their agendas, has been very useful. Over time, and I guess that would be the example from Chile, over time, it can become institutionalized. And when one of the caveats of private prosecution, which I did address at the beginning, is that I didn't see, if the public prosecutor is working, you don't really need the private prosecutor. If the investigation is being done, you don't really need that. And when you have a public prosecutor that works and that lets victims participate and bring, some feedback, then everything may work smoothly. The problem is when you have this clash with an inefficient or poorly funded or corrupt public prosecutor that doesn't want to do stuff. And that's where the private prosecution can have an impact. In this sense, the support structure is needed because it's an expensive right. And usually most of these victims do not have, it's very expensive to have a lawyer, and you have to have the energy, the legal skills to support a criminal process that takes years. So it's usually the institutional umbrella that provides an NGO helps victims' relatives to be able to cope with the issue of time. These processes, regardless of the country where you are, criminal cases take a long time. Criminal investigation in murder cases tends to be very difficult. And having an NGO assist you in the process gives, and this is why Chile is also important, and this is why the feeling of getting a quality of service, these NGOs and these private prosecutors get to cater that need of the victim, of helping them understand the process, helping them cope with the length of time of how much justice takes, and how to deal with the setback of a reversal or an appeal or a dismissal or an acquittal, and my English is failing me. But anyway, so this helps in that sense. So I think the support structure is needed in contexts where the public prosecutor is not really working. Over time, if you get to develop a stronger criminal justice system, a more efficient public prosecutor's office that doesn't violate due process rights and doesn't violate victims' rights, and so you have to balance those two, probably you won't need it. But I think they still give this purpose of helping victims assist in the process. There's some countries that understand the need for victims assistance, and they have incorporated victims offices in as you have like a public defense, you have a public victims defense office, and they tend to help victims in the process by giving them legal aid or legal assistance in the process. So I think over time, maybe we will see that, because the push is obviously to give victims more services and more attention. The need for protest and litigation, I think, comes precisely, like, they need to be used sometimes in conjunction, because to help press a state that is not willing to to do anything. So I think that will be useful and will be done for as long as you have an unresponsive state. And this brings into question, or to address the question of what is Mexico like nowadays. And I think one of the things that we see, especially in the case of femicide, but also disappearances, is that victims' organizations are using both these new legal resources, legal tools that private prosecution provides, with the support of protest, as well as any international legal tool that they can get their hands on. Because the government is not really improving in terms of dealing with organized crime, violence, and dealing with all these cases of not only murder cases, but also disappearances that linger there, like, for years. That's where I think the support structure is necessary. The protest is necessary to keep an eye on the issue, to help avoid oblivion, basically, to help the state not forget that they have to deal with this thing. And these kind of relates to a question that I had regarding how much highlighting human rights abuses can actually impact trust on government. And I think one of the things that is important is that when you have a country that upholds the rule of law, and this is something that in the US we should know because this is being discussed today, rulers as well as ruled should be equal under the law. And highlighting human rights violations and putting the spotlight on failures to prosecute those type of cases, like any type of human rights abuse, even putting kids in cages, like in the United States, or any other form of a violation, like not dealing with disappearances in the case of Mexico, is important, because that is the only way that you can say, this country is not upholding the rule of law. We still have these cases to deal with, and the state has to be kept accountable on those things. So I don't think it hurts trust in the system. I think it can help over time. It can help build the rule of law over time, but it's a long process. And this is one of the things that Janice was mentioning before. It takes a long time. So some of the most important human rights trials have taken 30 years, and 10 years ago, people would be like, oh, nothing is going to happen. But then stuff happened. It just takes a long time. What else? And this is why the issue of perceptions matter. Because on the one side, you want to trust the system. But on the other hand, what these cases show is that there are a bunch of people that they know the system is failing, but they trust enough that they're willing to place a bet on the system. So they're going through legal channels to try to highlight, hey, there's a human right violation. Hey, you are not acting as you should. So they're using protest, but at the same time, they're channeling their grievances through the legal system. And that, in a way, also helps for observers, basically, to say, okay, so they're using the system. Private prosecutors are using the legal system, which in a way, I think, increases legitimacy. If the choice was to, do vigilante justice, because you didn't get, that would definitely not be good for the rule of law or the strengthening of the criminal justice system. But using the legal system to try to highlight failures of the legal system and to try to keep state agents accountable for their decisions, I think that's important. And this is why I think using private prosecution is important. And this is why I think perceptions matter, in the sense that I think it's important for victims to know that even though things do not happen, they still have a channel to put their grievances there. But there's a difference, and I think this relates to the work that you've done on how people perceive justice. Like, what is justice? If it's punishment or just the process, or and I think that's an empirical question. Like, I don't think we know a lot how victims' relatives experience this process and how that impacts their perception on justice as well as their perception on the rule of law. But I think it helps strengthen it. That's my, I don't know, my assumption. Now about the US, and I think I have like a few minutes left before you have all to go, and before we wrap up. About the US, I think there could be reforms that introduce victims' rights. Victims in the US have virtually zero rights other than the right to be heard, which is you write a statement at the end and you are heard. The reason why I start the book with the Tamir Rice case is because Ohio has this weird possibility for you to contest through a judge, you know, to appeal to a judge, but the judge, whatever the judge decides, the public prosecutor doesn't have to, it's not enforceable, or it's not a really, they cannot obligate a prosecution to start if they don't want to. There are other things that you have a federal system, you have, you know, some states that have a grand jury and how you bring an indictment, and then you have the role of the public prosecutor in the grand jury, and you have all these different layers. And the sad thing about the US is that the only remedy left for victims' relatives is seeking money, restitution. And I think that's a mistake. Because historically, private prosecution was allowed in the US. It actually was kicked out of the system at the beginning of the 20th century, but it was here for many centuries. And if that is being changed towards including more participation rights in future reforms, I think it would be necessary. I think it's necessary for victims to have other ways to appeal prosecutorial decisions in the US. And last but not least, I want to address a question regarding how this relates to victims' rights in international courts, and how if they have anything to do, for instance, with the efforts of expanding victims' rights in the International Criminal Court. And the one thing I'm gonna say, because I literally have like 1 minute, is that Catherine Seeking has a very good book about the history, or the history of the impact of legal scholars in, or a chapter in one of her books, I'm trying to think which one it is now, about how legal scholars have impacted, Latin American legal scholars have impacted on the development of some of these international norms. There's a lot of mixture of history here, because private prosecution is a right that was part of Germanic and Nordic and very different legal systems. But the criminal procedure codes as drafted in Latin America were virtually inspired a little bit by German criminal procedure. So I think it kind of goes to Latin American legal scholarship, but also, and the impact that Latin American legal scholars had also in international forums pushing for human rights. They were inspired in a way by European criminal codes, but they pushed a lot for victims' rights in a UN forum, as well as in the drafting of the ICC. So I will leave it at that. Thank you everyone for attending. I think I've addressed most of the questions, and I don't know if you want to say anything else, Jan.
I think we're at time. Thank you all so much. Thank you, Michelle, for Professor Michel for this really fantastic, thought-provoking, important book. I really appreciate it, and I hope to see everybody in person sooner rather than later. Thank you, everybody. You're muted.
Sorry. That the silver lining, as I was mentioning before, is that I got to see a lot of folks from different places, and thank you everyone for coming, because it's also like, mid of the day, and I know everyone is working with many different things in this pandemic era. So thank you for stopping by. If you have questions, please email me. Be free to send me an email, vmichel@jj.cuny.edu. Thank you, Janice, Professor Janice Gallagher. My honor to have you here. Thank you, OAR, for hosting this book talk and for making this possible. And thank you for all my colleagues, friends, relatives that I see in the list, and some have already left, but it was very lovely to see some of you attending this talk. If anyone wants a copy of the book, I forgot to say, I have 5 free copies. You can email me. So it's a nice book. I have paperback edition, but you can get it for free if you send me an email, okay? Thank you, everyone. Thank you, Dan. Thank you, Rachel, for organizing this. And thank you, everyone, for stopping by.
Thank you both so much. That wraps up our book talk for today. We appreciate so much everyone staying with us to the end. So take care, everyone. Have a nice evening.
Thank you. Bye-bye.